people, what's going on? I'd like to talk about this R. Kelly situation because this shit is crazy. So for those of you guys who aren't familiar, they had just recently added a bunch of Jane Does and 2 John Does to the R. Kelly case. The prosecution just kindly threw that shit in there after the jury's questions have already been selected and submitted. How do you prepare for a trial with this shit thrown in there just like a week or 2 before trial's supposed to start? Like, this shit is ridiculous. All right, they're not giving this man a fair trial. It's not. He has a lot of his constitutional rights that are going to be violated. All right, and that's the truth of the matter. Whether if you support R. Kelly or you don't support R. Kelly, his constitutional rights are being violated. Especially with this new situation where the prosecution is bringing in all these additional Jane Does, 2 John Does. First and foremost, R. Kelly had just recently found out who the fucking Jane Does was, the 1 through 6. So these new Jane Does, they don't even know. R. Kelly don't know who the fuck they are. The John Does, R. Kelly don't know who the fuck they is. So this shit is just ridiculous to me. It's just ridiculous to me. Again, whether if you support him or you don't support him, this shit just is not right. They already did their jury questionnaires. You know what I mean? Before this had approached, they had already did their jury questionnaires. So let's say if R. Kelly was gay, okay, and he did like having sex with other men, that's his business. You know what I mean? That's his business. Nowadays, it don't matter. Now, the situation is that they submitted questions to the jury that had nothing to do with, being gay. Was it the LGBTQ? It had nothing to do with that. Had they had known that they was going to add the John Does into the situation, they would have made sure they asked questions to the jury to make sure that they supported or how they felt about that topic. So it's that right there. He's not going to get a fair trial based on that right there. They should have brought this up a long time ago. And then on top of that, so now what? He has to, I don't know. When they go up there to cross-examine every Jane Doe and every John Doe, they have to know what they're able to ask them to cross-examine them. You can't just have these Jane Does popping up and then the defense go over to R. Kelly like, all right, well, what's going on with them? You don't do that during trial. You do that pre-trial. You do that before trial, so you know what to ask these people. There's a couple things in here that I want to read directly out of here. All right, so I had a little interruption there. I'm back. So this is called the Memorandum of Law in opposition of the government's motion in limine to admit certain uncharged acts. So they're admitting uncharged acts. The fuck? Anyways, so this is a letter that was written by R. Kelly's defense team to the judge. Preliminary statement on this document. It says, Mr. Kelly respectfully submits this memorandum in opposition to the government's motion in limine to admit at trial evidence of certain acts by Mr. Kelly. The evidence of certain acts offered in the government's motion are unequivocally inadmissible under the federal rules of evidence because the government's request is untimely, not relevant, and if permitted will cause severe prejudice to Mr. Kelly, of which such prejudice outweighs their probative value. Therefore, if the court does not deny the government's motion, Mr. Kelly's constitutional rights will be violated, as well as his right to a fair trial. And then they go into this lack of timeliness by the government in producing the other act witnesses. The fuck? It says, understanding that the government in many federal criminal cases requests permission of the court for the use of evidence of an accused's extrinsic acts. I don't know if I said that word right, but extrinsic acts of which is viewed as an important asset in the government's case against an accused. The fact comes with the understanding that the certain time limits will be adhered to so as to not prejudice the defense. The 2020 amendments to rule number contains additional notice requirements placed on the government in a criminal case. This goes on, right? There's 13 pages. I'm going to jump all the way down. Opposition to the government's request to enter evidence of the defendant's other acts. There are 13 Jane Does and 2 John Does whose identities are still confidential. The court must determine admissibility of their proposed testimony by the government. None of the names of the Jane Does or John Does have been disclosed to the defense. Without disclosure of their names, it is merely impossible to adequately respond to the government's motion, especially given the fact that Mr. Kelly and defense have had a mere 7 days to respond. The standard for pretrial disclosure of witness is whether a specific showing of need for disclosure by the defendant outweighs a specific showing of need for concealment by the government. Excuse me. The Jane Does in the government's other acts motion are no less important than the Jane Does and John Does in the superseding indictment. A single Jane Doe or John Doe that is allowed to testify against the defendant must be met with the same rigorous cross-examination throughout the trial as Jane Doe's number 1 through 6 does. Therefore, without the knowledge of the identity of the Jane and John Does with whom the defense is entitled to thoroughly cross-examine, the defense is at a disadvantage when it comes to adequately preparing and effectively defending Mr. Kelly at trial. More importantly, it is impossible for the defense to make effective arguments necessary to combat the introduction of each witness proposed by the government when the defense is in the dark as to the identities of the Jane and John Doe. Alright, so with that being said, shit's fucked up. Now, they go in and they start to talk about Jane Doe number 1. Now, Jane Doe number 1 is allegedly Aaliyah, right? The deceased singer Aaliyah. This shit is wild. So anyways, I just want to say something real quick. And I like to say this a lot. If R. Kelly and Aaliyah had gotten married, don't you think there would be court documents? Don't you think that would be put in this case against R. Kelly? Don't you think that would have ever been put in the case against R. Kelly? Anyways, Jane Doe number 1, allegedly Aaliyah. The government seeks to introduce evidence regarding Mr. Kelly's alleged sexual abuse of Jane Doe number 1 to prove his motive for engaging in Racketeering Act 1 bribery. The defense believes the evidence the government seeks to admit lacks reliability, eviscerates Mr. Kelly's Sixth Amendment right to confront his accusers, and should be excluded for prejudice and or confusion under Rule number 403. Mr. Kelly has a right to confront his accusers. This right is a right which is guaranteed in the Confrontation Clause of the Sixth Amendment of the United States Constitution. Then they put in their little court law there. And it says testimonial statements of witnesses absent from the trial are admitted only when the declarant is unavailable, and only where the defendant has had a prior opportunity to cross-examine. Per Rule 804, hearsay exceptions. A declarant is unavailable if he or she is unable to be present or to testify at the hearing because of death or then existing physical or mental illness or infirmity. In the government's motion, presentations are made that sexual abuse of Jane Doe number 1 occurred at the hands of Mr. Kelly. The government asserts that while Jane Doe number 1 was 15 years old, Kelly believed Jane Doe had become pregnant. There is absolutely no physical proof nor circumstantial proof that any of those allegations put forth by the government are true. If you support R. Kelly, even if you don't support R. Kelly, you never heard shit about her being pregnant. Nobody. That would be definitely public knowledge to everybody when she was alive. Chow and Aaliyah said they never got married. You know what? Let me go ahead and keep on reading. So, Jane Doe number 1 is unable to testify that any of the above allegations are true. They are merely accusations that assist in forming the government's narrative. First, due to the unfortunate passing away of Jane Doe number 1 on August 25th, 2001, she is legally unavailable. Why bring this stuff up now and she's not here? Anyways, child. Second, the defendant has never had a prior opportunity to cross-examine Jane Doe number 1 prior to her passing away. Therefore, the additional information the government seeks to introduce regarding Jane Doe number 1 is nothing more than conjecture and an effort to further shape their narrative. That's all it is. That's all it is. In the government's last attempt to be granted permission to get their narrative in regarding to Jane Doe number 1, the government wrote, given Jane Doe number 1's age, the bribery charge in Racketeering Act 1 was necessary to effectuate the marriage. This sentence alone may be appropriate for jurors to hear when attempting to prove the bribery charge. The rest is an effort to support their narrative with no actual evidence to support such allegations. Lastly, Rule 403 does not support the evidence coming in. Rule 403 stands for the premise that the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issue, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. If the government somehow proves the evidence that they wish to admit is relevant, the allegations made regarding Jane Doe number 1 and Mr. Kelly still should not be allowed. Still should not be allowed in because of their probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, and misleading the jury. I'm just going to read this through. This is the last portion of this document. We are on page 11. Okay. It says there's 12 out of 13. We are on page 11. I'm going to finish this out. Very important for you guys to hear. Sexual abuse allegations. Jane Doe 7 through Jane Doe 20. In the event this court is prepared to allow Jane Doe 7 through Jane Doe 20 to testify, the defense vehemently objects. It is the defense's position that without knowing the names of Jane Doe 7 through Jane Doe 20, the defense cannot effectively show the court why each and every Jane Doe should be stricken. If the names of the Jane Does are revealed to the defense would certainly be able to promulgate, I probably said that word wrong, Promulgate, promulgate the proper response for objecting to their introduction under the law. However, given the time restraints in the trial schedule and with only 10 days left until the trial begins, the government should be rewarded for its untimely and late disclosure. More importantly, the court should consider all the reasons stated above in denying the government's motion as to Jane Doe 7 through Jane Doe 20. C. Sexual abuse allegations of John Doe 1 and 2. John Doe 1. John Doe 1. Allegedly, Richard Arline Jr. who's currently paid, who is currently, or was currently facing up to 15 years in prison for bribing one of the Jane Does in this case. Now all of a sudden he's added in as a John Doe. John Doe 1, John Doe 2. Allegedly, it's John Doe 1. So, the argument for striking John Doe 1 and John Doe is first executed under the timeless of the other act's evidence at the beginning of this motion. The second argument is the second argument for why the John Doe 1 and John Doe 2 should be stricken as 404B witnesses is the same argument as stated regarding the Jane Does. Without knowledge of the names of John Doe 1 and John Doe 2, the defense cannot effectively show the court why each of the John Does should be stricken. If the names of the John Does are revealed to the defense would certainly be able to promulgate the proper response for objecting to their introduction under the law. However, given the time restraints in the trial schedule and with only 10 days left until the trial begins, the government should be rewarded for its untimely and late disclosure. More importantly, the court should consider all the reasons stated above in denying the government's motion as to John Doe 1 and John 2. Conclusion. For the reasons set forth above, the government's motion in Lamine should be denied. Signed off by R. Kelly's defense team. Do me a favor, people. I hope I read that clear for you. Put it in the comments how you feel about things, how you feel about what I just read or what you saw in this video, what you heard in this video. Put it in the comments. Do me a favor, share this video, like the video, subscribe to the YouTube channel if you're not subscribed to the YouTube channel. Till next video. Thanks for watching.